Hello friends, this video, Technology Transfer Prerequisites, is brought to you by Origiin IP Solutions Bangalore, a leading intellectual property and legal firm in India. I request you to watch this video till the end, like and share this video and subscribe to our YouTube channel so that you do not miss any further updates from us. Thomas Alva Edison said, "Anything that would not sell, I do not want to invent. Its sale is proof of utility, and utility is success." This is a very powerful statement and indicates the relevance of technology transfer and sale of the invention, which of course is an integral part of cycle of innovation and IP. Before we move further, let's understand what is meant by technology transfer. Well, technology transfer, also called as transfer of technology, is the process of transferring technology from one person or organization that owns or holds it to the another person or organization. Why technology transfer? Technology transfer happens for various reasons. However, the basic reason is that buyer wants a new technology and seller wants an ecosystem where buyer can buy, manufacture and market the technology. Good technology transfer transaction is the one which is win-win for both buyer and seller. By transferring the technology, the seller gets faster access to the market both locally and globally. The buyer gets opportunity to acquire innovative and the latest technologies without R&D investment. Buyer and seller both may save huge investments and time, and there may be a possibility of good collaboration. By acquiring a new technology, the buyer accesses expertise of the seller, and this helps him to quickly launch the new and innovative product in the market. What does technology transfer mean to the buyer? Well, the buyer can have access to new technology. This way, R&D expenditure is minimized and expansion in IP portfolio happens if buyer gets IP assigned in its name. Now, let's see what does technology transfer mean to the seller. Seller or the innovator gets brilliant opportunity to bring technology to the market and understand the behavior of technology in a typical market scenario by getting into technology transfer deal. There are three prime ways in which technology transfer generally happens. First and the most common way is licensing, where technology is transferred for a specific period of time and the seller continues to own the technology. License can be granted by the seller to one or more parties depending upon the kind of agreement both parties have signed. Assignment is the permanent transfer of technology and ownership is formally transferred by the seller to buyer. Joint venture is a brilliant opportunity for both buyer and seller to come together and utilize each other's resources and build business together. Terms and conditions agreed between buyer and seller are regulated by technology transfer agreement. Now, the question arises, what gets transferred when transfer of technology happens? Well, as a part of technology transfer, there may be a process of making a product, various forms of intellectual properties like patent, copyright, design, trademark, or confidential information or trade secret know-how, which may be extremely sensitive and difficult to handle, or it may be product itself that gets transferred as a part of technology transfer deal. As a buyer, there are some fundamental steps that you should take before deciding to buy a technology. First of all, find out what is your need. Do you really need to buy a technology? Further, understand what you are buying. There should not be any mismatch between what you need and what you are buying. IP audit is must before you proceed with any discussions to find out validity, strength and term of IP protection. There are various ways you can find out exact value of the technology that you're going to buy, and right valuation of the technology should be done by the experts. As a buyer, you should never ignore finding out status of the technology if it is in the lab scale or pilot stage. Technology may work well at lab scale but fail at pilot or industrial level, so you have to be very careful about it as a buyer. If testing protocol of the technology is available, as a buyer you must be aware of it. Discuss with the seller clearly in how many countries will you be using the technology. Find out the kind of intellectual property that relates to the technology, and if IP has been filed or registered, you must have complete knowledge about it. IP registration status affects value of the technology to a very large extent. As a buyer, if you are getting IP assigned in your name, do not ignore cost of assignment and subsequent renewal with respect to the intellectual property that you are going to acquire. Now, as a seller, you must be clear about the scope of rights that you are going to give to the buyer. Selling your technology to the right buyer is important to avoid the problems later. As a developer of technology, your experience is of great value to the seller, and you must be aware of transferring know how in the process of technology transfer. Before you get into any technology transfer deal, get the right valuation done by the expert. After buyer and seller discuss terms and conditions, technology transfer agreement is executed, and typically the main clauses of the agreement are exclusivity. Here, between buyer and seller, there may be exclusive or non-exclusive agreement. Grant of rights. This is the clause where seller grants a set of rights to the buyer. Jurisdiction. This clause defines for how many countries the rights are to be granted. IP and know-how clause determines the kind of IP and know-how that gets transferred as per terms and conditions of this technology transfer agreement. Audit is an important clause for both parties where the seller may get right to audit premises of the buyer to ensure if buyer is using the technology as per terms and conditions of the agreement or not. This audit may be extended to financial audit. Royalty is again a very important clause wherein the amount and mode of payment is described in detail. Dispute resolution. When two parties decide to work together, there may be disputes in due course of time, and this clause explains how the disputes are going to be resolved. Term of the agreement is the essential clause of any agreement, and this has to be defined in the agreement clearly. Governing law is also an compulsory clause of the agreement. Every agreement is governed by law of a particular country, and you must have it clearly mentioned in the agreement. Though there are lots of advantages of technology transfer for the buyer and seller, but there are some risks also. Technology bought by the buyer may not work, high royalties may be difficult to pay, product may fail in the market, technology may become obsolete later, there may be unavoidable or one sided beneficial clauses in the agreement, lack of technical expertise or support may make life of buyer miserable. Because of all these reasons, survival in the market may become difficult. Let's take one case study, which is earliest known case of technology transfer. It's about biochemist at University of Wisconsin, Harry Steenbock. He discovered that irradiating food increased its vitamin D content, thereby making food healthy. Quaker Oats offered 1 million USD for vitamin D fortification patent. However, Harry allowed University of Wisconsin to come into license agreement with Quaker Oats. Revenue generated by this was given to the university to fund further research. Till date, University of Wisconsin has earned more than 300 million USD from this vitamin D patent portfolio, and this happened long back, sometime in 1925. Next case study is very interesting, and it's about Mysore Paints and Varnish Limited. This is the only company in India that is authorized to produce indelible ink. In 1951-52, Election Commission noticed several cases of identity theft taking place during election. To stop people from casting more than one vote, the commission reached out to National Physical Laboratory of India (NPL), requesting them to develop a unique ink formula that would not be easily wiped off, making sure that elections were carried out in fair manner. NPL devised a closely guarded secret formula and approached the company Mysore Paints and Varnish Limited to manufacture the ink. To date, this company remains the sole manufacturer of this ink, which supplied to 35 countries across the world, including Afghanistan, Turkey, Singapore, Canada, as well as most of India's neighboring nations, and has inked close to 4.5 billion people as of 2015. From its first use in the third general elections of 1962, the ink has almost completely stopped any kind of identity theft during the voting period. However, in a country as overpopulated as India, where illiteracy is rampant, the use of indelible ink is a easier method of keeping a check on any misgivings. The formula is unknown and the ink is said to be made with small amounts of silver nitrate, which reacts to light, marking a voter's finger for up to 3 to 4 weeks. It cannot be simply washed away or removed by any known chemical or solvent. Since the ink is photosensitive in nature, it darkens when exposed to sunlight or even indoor light. This is a very beautiful case of technology transfer where NPL developed a technology and protected it by maintaining a trade secret. Technology, in this case, was brought to commercial use by transferring it to the right industry partner. There are some interesting facts related to technology transfer in Israel. In Israel, 4.2% of its GDP is spent on civil research and development, which is one of the highest ratios in the world. Israel ranks fifth among the most innovative countries in the Bloomberg Innovation Index. Israel counts 140 scientists and technicians per 10,000 employees, which is one of the highest ratios in the world. Israel also has world's most technological literate populations. Israel's first university technology transfer unit, YEDA, was established by the Weizmann Institute of Science in 1950s. Universities here they have their own policies. Between year 2004 and 2013, the university's share of patent applications constituted 10 to 12% of total inventive activity of Israeli applicants. This is one of the highest shares in the world and is largely due to intensive activity of universities' technology transfer offices. Israel Patent Office is increasing the resources and upgrading enforcement activities. They have been implementing programs to bring ideas funded by government research to the market. Between 2002 to 2012, foreigner accounted for nearly 80% of patent applications filed with Israel Patent Office. So, just to conclude this video, technology transfer is a wonderful way by which seller and buyer of the technology can join hands to bring out innovative products in the market. Need of the hour is to understand market need, enter into right partnership, assess pros and cons of technology transfer, and then take the right decision. Thank you for watching this video. For any queries related to IP and legal services, you can contact us. Email ID and phone number is given in the video description. Thank you.